Number 45, matter of Marine Holdings versus New York City Commission on Human Rights. Counsel?
Good afternoon. May it please the Court. Mackenzie Fellow for the New York City Commission on Human Rights. May I please have 3 minutes for rebuttal?
3 minutes?
Yes, please.
You may.
Thank you. This Court should reverse the Second Department's decision because the Court misapplied the burden of proof and the substantial evidence standard. The Court's decision did not even mention the burden of proof or the fact that the landlord had completed a similar renovation at a similar building 300 yards away.
Do we have to send it back if we agree with you? If they applied the wrong standard, do we have to send it back to them?
No, this Court can apply the correct standard and then reverse the Second Department's decision, and that could be the end of the case.
I have a procedural question. This goes out to an administrative law judge, and the commission is a party in that proceeding.
Yes.
And the administrative law judge writes this extensive decision we have in the record, and then that goes to the commission, who's now acting as a decision maker.
Yes.
And not surprisingly, they agree with the position they took as a party before the neutral
Sure.
fact finder. So is there some type of standard you would apply in reviewing the administrative law judge's decision that would in some way make that meaningful? Because otherwise, why would the commission never agree with itself as a litigant?
Well, the prosecuting arm there's a prosecuting arm and then a deciding arm. So there's a separation at the agency. And this is very common. There are many administrative agencies that do this. The NLRB in the federal level, many other agencies have they prosecute cases and then they also decide cases. It's not
Like
very...
the SEC?
I believe so, yes.
So,
At the state level, the SLA does the same thing at the state level.
Right. I don't think it's not uncommon. It's pretty common, and the same standard applies, which is that the decision has to be supported by substantial evidence in the record, and that's what we have here.
So in this case, then, the record and the substantial evidence we would be looking for would be in the record created before the ALJ?
Right. That is the record that was before the commission when it made its decision. And that record has some evidence showing that the proposed work would be very difficult and other evidence showing that it would not be that difficult. And under those circumstances, an administrative agency's decision is entitled to deference from the courts. And the Second Department really overstepped by not even really asking that question. They didn't even ask the right question, whether the commission's decision was supported by substantial evidence. Instead, they said that the landlord had made a showing which the commission did not rebut. That was not the question before the court. And it's not clear at all
I
that...
take that language, though, to mean, and we've seen this in criminal cases, it seems to me that language is, as I said, in a criminal case, you say the defendant never has the burden of proof. But if the government has proved something beyond a reasonable doubt, and nothing is offered to, use the term, rebut that, then it goes this way. And it seems to me, while inartful and in ways unfortunate, they suggest they use that term, what they were saying was the same thing, essentially, that the landlord here had met their burden, they were going to win. And if you don't want them to win after meeting that burden, you, as a party, then have to do something to push that back over the line. Why isn't that right?
Well, it's not clear that that is what the court was doing. The court discussed whether the landlord had made a showing, and the 3 cases that the court cited all involved, they were all cases where the prosecuting agency did have the burden of proof. So it is not clear at all that the court applied the correct burden. And maybe if we had 100 cases like this, that wouldn't be such a big deal. But this is the only appellate division case discussing a landlord's obligation to accommodate a tenant under the city law. So in the future, when landlords are trying to figure out what are their obligations, this is the case they're going to read. And they're going to think all they have to do is make a showing, in which case the burden shifts to the commission to rebut it.
And as I understand your position, correct me if I'm wrong, although there were experts on the commission side of this, but with or without them, there was an inference from the accommodation, or not, it wasn't an accommodation before, but the renovations that had been made on the other unit in the complex, and that in and of itself constituted some evidence that the landlord didn't counter sufficiently.
That's exactly right.
Is that your?
The
okay.
fact is that they found it feasible to cut through a cinder block building and install a ramp. They presented an
Well,
art.
that may be feasible. What about the whole issue of having to cut the gas lines, displace people, and what do we do with the fact that you have the architect saying one thing, but the structural engineer saying something different, and even the architects have a bunch of caveats saying, well, we're not structural engineers.
Sure. It's true that the structural engineer, on the one hand, testified that he thought this work would be extremely complicated so that it constituted an undue hardship. But on the other hand, you do have two architects who thought it could be done more easily. The fact that they had done something similar, a commission employee who had testified that in his
So the commission had no obligation to put in a structural engineer when you're talking about the integrity of the building?
No. The question before the commission was whether there was evidence in the record as a whole that the landlord had met their burden of proving undue hardship. And there is evidence here sufficient for the commission to have decided that they did not meet their burden.
Let's assume that was true just for purposes of this discussion, that you would have to just, take people out of the building, there's a gas line issue, and you would at the minimum have to relocate tenants, and that was in the record and undisputed. Would that satisfy the landlord's burden?
That would probably satisfy the landlord's burden. But here, they did similar work at another building, and there is no evidence that it required the evacuation of tenants or anything like that.
Isn't the issue, again, wasn't the issue whether the structural strength of the cinder blocks and that the concern that they would fall apart,
That's
right?
exactly
And
right.
that's what didn't happen, as far as we know, in the prior renovation, and that was so.
That's exactly
that's
right.
the issue, right?
The fact is, they found it structurally feasible to do this kind of work when it benefited them. And their expert did not explain satisfactorily why they can't do it for Mrs. Politis.
Thank you, counsel. Counsel?
Avery Zalman, for the respondent, Herrick Feinstein. May it please the court, good afternoon. What was very different about the management office and the accommodation being sought here by the complainant is that it's clear in the record, the management office, the door, did not expand widthwise or lengthwise the window that was there prior.
I thought Santofsky wasn't clear about that at all.
In fact, the commission's so-called expert, the architect, admitted that for the accommodation that they were seeking, it needed to be expanded at least 2 to 3 feet across, which would remove the lentils, which would require, as the structural engineer, the only structural engineer to testify, more than substantial evidence, would require a complicated pin shoring that would require basically the demolition of the building and the rebuilding of the building.
Is there evidence in the record, and if so, can you point me to it, as to what the width of the window in the Politis' apartment was and what the width of her wheelchair is?
There's evidence, I can't point to that exact, but there's evidence that in the record from Mr. Givaxier, and that's 656 through 60, 686 in the record and 578 in the record, that there was no widening of the window in the management office, while the Politis window would have to be widened, and I'm quoting, by 1 to 2 feet.
Wait, but was that Santofsky's testimony before cross-examination? Because if that's what it was, I thought he pulled back on that and said, I don't know what the width of the window was in the office or whether it was wide.
I believe that's what he testified to, but there's more. Underneath the management office, it's apples and oranges, there was a small crawl space, which pin shoring could have been set up very easily without necessitating the evacuation of anybody because there's no gas lines, there was no electric lines. Where Miss Politis' apartment was, there was a complex lines of gas, electric, that needed to be cut off. There was a full basement that had exits, emergency exits, that would have been blocked. The widening would have required the pin shoring. The widening would have required the removal of close to 150 residents. That's an undue hardship to the building's business, which requires it to house people. In fact, the Politises were offered alternative. I
What
apologize.
you're suggesting is that there was some evidence, but the commission didn't have to accept that evidence when there was other evidence to the contrary.
There was no evidence to the contrary. They looked at a different building in a different place under completely different circumstances and said, if you could do it there, then you could do it here. Saratovsky, the only structural engineer, said it couldn't be done. It's structurally infeasible. The building may collapse. People would have to be moved out. That was different because of the electric, gas, and the basement went all the way down. So the pin shoring would have to go from the top of the building all the way down. Additionally, where the ramp would go would ease up against the building, causing the building to collapse just from the building of the ramp up against the building. In fact,
Excuse me, how many stories is the building?
the building is, I believe, 4 stories, including the basement. I think it's 4 stories, 4 or 5 stories. There are pictures in the record. What's interesting is though, the commission's architect, to whom they rely upon, in his first report, didn't even mention this reasonable accommodation. In fact, it wasn't in his report. It was only after the commission received the report that a member of the commission staff sent an email to Mr. Giavoxer, the architect, who, by the way, never went to the location, never visited the location, was unaware of the fact that the building was built with cinder block, which is obviously not a strong material. The commission investigator emailed, and this is in the record, at 896 to 97, can you at least reference the fact that to remove the window and replace it with a door appears, quote, to be a reasonable accommodation? The commission itself, their investigators, told the expert what to put in his report and what conclusion to find.
But isn't the problem for us, and even accepting the validity of your factual arguments, which you're going to know more about this than any of us here, isn't the problem with us really, our question is really, what's the standard of proof here? And it seems that your argument requires us to weigh the opinions of 2 experts and decide which one makes more sense, rather than just deciding whether or not the commission had a rational basis for the decision that they made.
It's up to the court to look at.
We would have to say
apologize.
that, no, it's okay. We would have to say that the commission's decision was essentially totally irrational. And can we do that on this record?
Absolutely. The standard is substantial evidence. There is no evidence at all. And this is not burden shifting in any
you
way.
keep saying that, and I think that the question becomes, do they need to have a like expert, another structural engineer, or is the testimony of their architects, who are concededly not structural engineers, enough?
It's not even
Even if it's not how we would have reweighed it, or if we could reweigh it, or how we would have weighed it in the first instance.
It's not even the architect. The architect, there was an architect that was called by the commission, an architect that we engaged initially, who made it clear, I'm just an architect. When you remove walls of buildings, you need to bring in a structural engineer. Look, can it be done? Anything's possible, but you have to consult with the structural engineer. What was my client supposed to do? They got a complaint from the Human Rights Commission. You have to blow through a kitchen window in the back of someone's apartment and build a ramp.
Well,
So
why
the first thing they
wouldn't-
did
why
is
wouldn't
they
the
engaged a
why
structural
wouldn't the
engineer.
simple thing, you said, what would your client have to do? Why wouldn't the simple thing be to put it out for bid? And see if anybody said, yeah, I'll do this for X, or everybody said, you know, I can't do this except for maybe Y, you know, which is a huge amount of money, or I can't do it at all.
Before the construction crew has to come in, you have to get a structural engineer. So they engaged a structural engineer, Mr. Saratovsky. They said, this is what we're being asked to do by the commission, not the buildings department, not anyone with any expertise with regard to this building, by Human Rights Commission. Can it be done? Saratovsky's the only person in the record that actually went down and visited the building, because the commission's expert did not. He assessed the entire situation. In fact, he even visited where the management office, he went to the management office, he went in the crawl space, and he recognized the difference of putting pin shoring in a place where the foundation is a few inches from the ground level, as opposed to the foundation
But aren't
being
you
in the
talking
basement.
there then really about money, and which is something that your client didn't make an issue in this case at all? So, you know, maybe it's a more extensive process to do this shoring with the different ways the buildings are constructed, but doesn't mean it can't be done and it's not feasible. Maybe it's just a lot more expensive, but we can't consider that issue here, right?
It has nothing to do with money. This has nothing to do with money. The human rights law expressly states that such accommodation that can be made that shall not cause an undue hardship in the conduct of the covered entity's business.
Yes, no,
And
I
including the
understand that.
factors.
It doesn't have to be financial. But,
Absolutely not.
But here, I'm having trouble separating them out and saying that financial has nothing to do with it, because, in fact, one of the experts said, if money was no object, then sure, we could do this.
That's not what the record is, with all due respect to the court. It's not what the record was. The question was, is it possible? And the expert said, it's possible, and that's not the standard. Anything is possible. It's the nature and cost of the accommodation, the nature, and additionally, under the other factor in the human rights law, it's the impact otherwise of such accommodation upon the operation of the facility. Here, there's no question that they would have to take out close to 100 other residents would have to be removed for close to 6 months, even if this could be
Well, there was a question,
done.
because some of the witnesses said, oh, this is a piece of cake. This is done all the time. You don't have to remove all these tenants.
The person who said that was an architect who admitted on the record that certainly he would engage a structural engineer to get the structural engineer's point and, you know, recommendation regarding it. The individual who said it didn't even put this accommodation in his report until the commission told him to reach this conclusion.
Counsel, do you care to take another moment and address the burden shifting argument?
There is no burden shifting here. When the court, the appellate division says rebut, according to Black's Law Dictionary and the way attorneys operate, rebut means taking away the effect of something. So we met our burden. We met our burden. Substantial evidence, structurally infeasible, structural engineer explaining why it's structurally infeasible to the T, over and over and over again. Because the commission decided either to put on evidence or not to put on substantial evidence or not to put on evidence at all, that's up to the commission. That in no way shifts the burden, but rebut just means taking away the effect of something. And here, arguably, they took away the effect of nothing because there is no evidence. The only evidence they continue to point to is the management office. Well, anyone could say, well, they did it down the block. Why can't you do it here? We explained why it was different in detail. We examined the management office, and we entertained that as an option, and we explained by the substantial evidence why it's not. It's not two options here, and the commission decided one, and the appellate division wrongfully decided the other. There really isn't only one option here. The substantial evidence expressly provides that this would either cause the building to collapse, necessitate the evacuation, or both. And that is an undue hardship. If I'm supposed to provide housing for people, I can't. What's also important for the court to recognize is that the Politises were offered an apartment, a free move to a different apartment 15 minutes away. Now, I understand it wasn't the community that they wanted to remain in, but that was reasonable as opposed to causing a building to collapse or risking the collapse of a building. And that building was completely accessible, and the rent was exactly the same, and the moving expenses were going to be paid for by my client as a reasonable accommodation, recognizing that when a structural engineer tells an owner of a building, don't do it, it's not feasible, the building may collapse, you're risking people's lives.
Thank you, counsel.
I don't think
Thank
they
you.
had much of a choice.
Thank you, sir.
Thank you.
Counsel, what about your colleague's emphasis on the removal of 150 residents in the building?
First of all, that was not even the engineer's testimony. He said a couple of apartments, and when you look at why he thought that would be needed, it's not very clear. He said the gas lines would have to be cut off at certain times, but he didn't say when. And certainly, there's no evidence that they had to evacuate tenants when they did it at the other building. And other evidence in the record shows that this kind of renovation is regularly done without requiring evacuation of any tenants. I would like to answer the question about the width of the door. In fact, there is actually evidence in the record that Mrs. Politis' window is almost 34 inches wide, 33 3/4, and that's at R443 at 876. An ADA accessible door has to be 32 inches. That's in 28 CFR Part 36.
And that was Mr. Tilley's testimony also, I think, right? 32 inches.
Exactly, that's exactly right. This window does not have, there's no evidence, well, some witnesses did testify that they thought the window had to be widened, but they never explained the basis of their belief for that. And the only person to have measured the window shows that it does not need to be widened. And that was actually much of the reason for the engineer's belief that this work was going to cause so much difficulty, was his belief that the window had to be widened, which is
At least
not.
as I understood his testimony, the pin shoring is dependent upon the need to widen the opening, right? So if you-
Much of his testimony was based on that. He also did seem to believe that you just cannot cut through cinder block, but obviously, this landlord found it feasible to cut through cinder block without
Or-
imposing any hardship on
Or
their
didn't
residents.
have to cut through the cinder block because the opening was already large enough.
Well, they still would need to cut the blocks below the window, but it seems, I mean,
Those
I'm not a
blocks are not
structural engineer,
structural
but they're not,
vertically,
those
yeah.
blocks are not, clearly not as important as the ones to the side of the window. My colleague here makes a big deal about the fact the architect versus a structural engineer, but in fact, when we first proposed this accommodation, they themselves hired an architect. They obviously thought an architect's opinion was worth something. And then when that report came back and said that this work was feasible, they hid that report. And we had to get an ALJ to order them to turn it over. And that also shows that they believe that report does have evidentiary value. And while that architect did say that he would hire a structural engineer, it's very clear when you read his testimony at R372, he would not hire the engineer to find out if this was feasible, but how to do it, whether the work could be done without shoring or if shoring was needed. So there is certainly substantial evidence in the record here that they could do this work. We're not asking them to build the Brooklyn Bridge. We're asking them to turn a window into a door and install a ramp, something that they found feasible to do when it suited them, and their refusal to do it for Mrs. Politis is discrimination, and it's illegal.
Thank you, counsel.
Thank you.